So,
Hi, David.
nice to talk to you.
Good to talk to you. It's good for me to be back on Blogging Heads. I've been on a sort of Blogging Heads hiatus for the last, 5 or 6 months.
Oh my goodness, what happened?
I don't know. I sort of went underwater into a world consisting entirely of small children and sippy cups and survival mode. But I'm back.
Yes, all right. I remember that world.
How old are your kids?
16, 14, and 6.
Oh. Did they want to babysit?
Yes, actually. My daughter's going to Paris for the summer, and she's trying everything she can to earn money.
Okay, well, cool. I'll talk to you later.
All right. Do the transactions on this side.
Right.
So we're going to start by talking about Boumediene.
Yes, Boumediene. Another 5-4 decision. Will it kill Americans? Will it save America?
Well, I've been influenced actually on this by a previous Blogging Heads discussion with Brink Lindsay, who's an old friend of mine. He's at Cato now. He and I were president, vice president, and I think the only 2 members of the Harvard Law School chapter of the Federalist Society back in the late 80s.
Really?
Yeah, we're 2 years apart from Barack Obama, actually. So
this is kind of a sad story. You were the only 2 members?
We're the only 2. I think there may have been 1 or 2 others, but
it
was a very, very small
What
group.
kind of functions did you have? What kind of debates did you have?
We had a lot of actually distinguished visitors that we brought to campus, and we would occasionally have functions where the dean of the law school would make clear that while he condemned our views as severely as possible, we did have a right to express them. Anyway, but about Brink, I reacted very badly to the decision. It seemed to me legally bizarre, unprecedented. The consequences seemed horrible. But I think one of the things I took away from that discussion that has made an impression on me is that even though the decision I think is legally very hard to defend, it does make more psychological sense. That is to say that the court seems to have taken the view, as it's taken in the past, that a president has a certain number of years to wrap up a conflict.
Right.
And I'm thinking here of very much of a case that's sort of like Boumediene, ex parte Milligan. Now that involved genuine American citizens. In Milligan's case, he was a civilian detained during the Civil War when President Lincoln suspended the writ of habeas corpus without involving Congress, which is not what the Constitution says you should do. And the court then freed Milligan and said he should never have been detained, but they said that in 1866.
Right.
And they gave Lincoln 3 or 4 years to do what he wanted, and by the time that Milligan got his freedom, well, I think it was Milligan. Was Milligan the prisoner, or was he the person who did the detention?
We know what you mean.
But by the time the case is wrapped up, so was the Civil War. In this case, the war's been going on for a long time. There have been no military tribunals, as there ought to have been, and although there are various excuses for that, none of them are really tremendously convincing. And I think you can understand psychologically that the court would say, if you're not going to advance with these military tribunals, then we're going to involve the federal court system, unprecedented though that is.
Okay, well, let me just take a step back for the benefit of any BHTV viewers who can't remember what case we're talking about. This, of course, is the case the Supreme Court decided a couple weeks ago, 5-4 decision, opinion by Justice Kennedy, which struck down a portion of the 2006 Military Commissions Act and said specifically that the Guantanamo detainees do have habeas corpus rights, which concretely means that they have the right to go to U.S. civilian federal courts and ask those courts to rule on the validity of their continued detention. Let me distinguish between 2 pieces of what you just said, but both of which I think are interesting. One of which I completely agree with you. The other, unsurprisingly, I don't. Your sort of psychological analysis and your legal and historical analysis, on the other hand, you're arguing that psychologically the explanation for this is that the court kind of said, Bush, you had your chance and you blew it, and we're tired of this stuff. Stop messing around.
Or just time's up.
Time's up.
Roosevelt did.
Totally right.
Roosevelt cut a lot of corners. Right. Wilson cut a lot of corners. Lincoln
Right.
cut a lot
Right.
of corners, and then we tidied up afterwards. But you've taken
You had too long.
7 years.
Right.
We're tied now. It's time to tidy up.
That piece of it I completely agree with, and I think there are all kinds of ironies here. One of which is that, if Congress had passed the Military Commissions Act back in 2003 or 2004, and those military commissions had gotten up and running promptly and so forth, and trials had proceeded and there were convictions, I don't think the Supreme Court would have had any problem with it. If there had been a reasonably speedy, reasonably transparent process with military commissions at Guantanamo, none of this would be happening. So I think there's no question about it. Part of what's going on here is the court is just saying, you've got these people who've been held now for 6 years in some cases, more than 6 years in some cases, and there's been no process whatsoever, and you're kind of screwing around, and time is up. And time is up, and we've kind of slapped you on a bunch of occasions and said, get your act together, and you haven't done it, and time's up. So I think that's right. Where I disagree with you, unsurprisingly, is I don't think that this is either legally unjustified or historically unprecedented. I think there's a sort of a fake way to frame it, which makes it sound historically unprecedented. When you sort of go, never before in the history. I've heard this. I'm sort of putting words into your mouth here, I know, but I've sort of heard some variant of the following claim from lots of different people. Never before in the history of the universe, has a civilian courts sought to tie the hands of the president in a time of battle, blah, 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 taking combatants.
Don't cartoon the view. It's a serious view.
No, it's a serious view.
Never before in American history have the federal courts intervened in foreign military combat operations, or in the POW, or in the holding of POWs. That's just not something the courts do.
But here's the difference, David. I mean, and here's where I think that here's where I think the court is coming from on this. That's all true as a simple blanket statement, but what I think the court is disagreeing with this is that this category of persons are the same category of foreign enemy combatants captured on the battlefield in a war that is like other wars. That to the extent that there's a sort of generic statement made saying, look, under the laws of war, the detaining authority can use military commissions, detain people indefinitely. It's not the civilian court's business, etc. Sure, fine. But these folks are very different in all kinds of really significant ways, legally significant ways, politically significant ways, morally significant ways, from other categories of detainees in other kinds of conflicts. And I think the court is saying that actually matters here.
That is what the court is saying. The question doesn't make any sense.
Right.
If these detainees, now let's, as a legal matter,
right.
If these detainees have due process rights, where did they get them from? Mm-hmm. The United States Constitution regulates two things. It regulates the relationships between different parts of the U.S. government, and it regulates the rights of American citizens as against the U.S. government and other component governments. Now, these people are not U.S. citizens, so it's pretty...
Well, the U.S. Constitution also regulates the rights of persons in U.S. territory, and Guantanamo is part of U.S. territory. And as we know, there's a somewhat lesser extent to which constitutional rights do extend to non-U.S. citizens and so forth, but clearly there are some rights.
We had tens of thousands of German prisoners of war on American soil during World War II.
Sure.
By the way, and during the Civil War, the U.S. government detained tens of thousands of American citizens on American soil, captured Confederate soldiers. It would have struck everyone as crazy if any of them had made a claim to the U.S. court. Any U.S. court that, I've captured, the fact that you're on U.S. soil, the fact that you're a non-citizen, enemy combatant, you can't go to the courts, and the courts have never before even considered such a thing.
But you're assuming, I think, precisely what the Supreme Court is saying needs to be demonstrated here. I mean,
Sorry, no, because if Hans the pastry cook, who was swept up in a U.S. combat operation in Germany in 1945 and was sent to a POW camp, tried to get a U.S. court to say, I'm a pastry cook. I'm not. No court would have heard that case.
I think here is what is different about this situation that we're in right now. We have, and the U.S. government has essentially said this many, many times. Most of the Guantanamo detainees we're talking about, many of them, and it varies from person to person, were not detained on the battlefield by U.S. forces. Some of them were detained on battlefields by allies of the U.S. Some of them were simply apprehended in other countries far removed from any active conflict whatsoever, e.g. in Bosnia and Africa and other places. We haven't had a fair process one way or the other for determining who they are by the military's own admission. Many of them have been in the wrong place.
But you just skipped over the key point of the question. Where did they get these rights from? You said they haven't had a process. Where did they get a right to process?
Let me finish. To the extent that we don't know one way or the other whether they're enemy combatants in the first place, I think that's what the Supreme Court is saying. They're saying that they have some right, especially after 6 years, to go to somebody and say, hold on a second here. I'm not saying I should be let go necessarily, but I'm saying somebody should be some fair proceeding. I have a right to have some fair proceeding rule on whether I should continue to be detained in this process.
Well, you're completely right. That's what they're saying. But that's just not law.
Well,
supposing I were an inhabitant.
Let me put it to you like this. Let me put it to you in a different situation. Let's say the U.S. government, for sinister, bizarre reasons of some, let's say a rogue U.S. official, someone who's just completely nuts off the reservation, has some personal vendetta, goes off to Kenya, picks some guy off the street randomly, says, I don't like the way you look, kidnaps him, dumps him in Guantanamo, says, this guy's an enemy combatant, and the guy gets detained forever. He's 6 years later. The question, what the court is essentially saying is, in this kind of context, after 6 years when there's no battlefield, and we're far, far, far removed from any battlefield, and there's been no adequate process, we're not going to take the government's word for it that these guys are enemy combatants who can be detained indefinitely, when we've seen so much bad faith that there needs to be a process. They haven't provided an adequate process, and so we're going to say that the federal courts are going to be that bare minimum process to let these guys go to a fair tribunal and say, Your Honor, give me a fair opportunity to just make the case that I'm not who they think I am, I'm innocent, and if you find I'm not, then back I go to Guantanamo, to be put through the military commissions or whatever.
Rosa, your defense simply encapsulates everything that is wrong with this case. That it's just not law. I mean, that you can create to say there's some injustice or somebody has something has been done wrong to somebody is not the same thing as to say they have a legal claim. I mean, the hypothetical you just made up, that's a civil case of somebody, some American citizen who happens to work for the government engaging in a tort against a foreign national. Now, those are of course that's justiciable.
And if that person is detained by the U.S. government, they absolutely have habeas rights. If they're detained by the U.S. government and held in U.S. territory, they absolutely have habeas rights.
Now, what you're claiming here is that these detainees have as a group, all of them, some kind of right of habeas corpus, despite Article 1, Section 8 of the Constitution, which gives Congress plenary authority over the war-making of the United States. Despite Article 1, Section 8 gives Congress the right to make rules about taking captives all over the world. It has that right is plenary. And habeas corpus rights are given by the Constitution. They also are described and discussed. And the question is, where do these people get these rights from? And that's the kind of analysis that lawyers do.
Sure, David,
and that's the kind of analysis that the Supreme Court just skipped past.
The Court makes it perfectly clear. Congress can choose to suspend the habeas corpus altogether if it wants to, but it didn't in the Military Commissions Act.
But you don't have to suspend habeas corpus rights for people who don't have them. These are foreign nationals.
But these people,
they don't have due process rights as against the U.S. government.
David, that's just constitutionally and legally wrong. Take it out of my Guantanamo context, okay? Let's take a different example. Let's say we've got a foreign national who's living in Tulsa, Oklahoma.
No, these are foreign belligerents. I shouldn't have said foreign nationals.
But again, you're assuming what you need to prove. That's what the court is saying. Let's say we've got a guy who's Hispanic, who's a foreign national. He's Mexican. He's a Mexican national. He's living in Tulsa, Oklahoma. Foreign
nationals on American soil who are non-belligerents do have various kinds of constitutional rights. That's true.
But that's exactly the point the Supreme Court is making.
But
the question.
Wait. But the question you need to ask is, how is this different from Hans the pastry cook, who got swept up in a U.S. military operation in 1944 and is being is in that same prison camp in Tulsa?
Here's the question. Here's the question. If the federal government, if the executive branch of the federal government plucks our Mexican national off the streets in Tulsa, and the guy is completely innocent, and just say because they've been bribed, because they're crazy, for whatever reason of their own, this guy is an enemy combatant. And it's not true, and there's not a shred of evidence, and then they lock him up in federal lockup in Tulsa, Oklahoma. There's no question that that guy has habeas rights. No question about it. Okay. Guantanamo is also U.S. territory. That's the situation that we're in. What the question, and I understand what you're saying, and let me give you this, okay? I'll give you something here. You're arguing. You're essentially saying, Rosa, that's not what we're dealing with here. We're not in fact dealing with a group of people who, were picked up by random rogue maniacs in Tulsa, Oklahoma. We're dealing with a group of people who, in one context or another, the U.S. government does have some reason to think really are belligerents. To which I'm saying, I accept that. I accept that. That in
it's got nothing to do with. Sorry, that's really the
problem.
wrong.
But the problem is, and here's what the court is worried about. The problem. I mean, there are a bunch of different issues to unpack here. But the problem is that what the court is saying, the federal government has been unwilling consistently to have any process to make any effort to determine who's a belligerent or who's not.
I'm afraid you're repeating the same point over and over again, and it doesn't make it any more forceful by saying it more often.
Tell me where I'm wrong, David.
Well, it was wrong the first time. The question.
I'll make a new point next time.
The question that I keep asking is, when you say never before in the history of the Republic, never before in the history of the Republic has a civilian court said we are going to second guess the detention of belligerents, and people who are detained during combat operations. We're not going to give them a right to contest that. Hans the pastry cook does not get the right. I'm now going to repeat a point. Who's swept up by the U.S. Army in 1944 and is interned in Tulsa doesn't get a claim to U.S. federal court. He may have some other kind of process. He may have some right to appeal to the military people, but the courts have deferred to the military. Now we understand now why they haven't done it. But the reasons for not doing it are not legal. They are psychological. Now, the Constitution has done it, so I guess it's in the law. But I suppose, and I mean, it's a legal fact that they've ruled this way, and the United States is going to have to accommodate it. But it is a departure. And what has happened here, and I think one of the things, and this is one of the reasons why this case has become so exciting to legal conservatives and legal liberals, is one of the big pending questions in global law is where do rights come from? Do national boundaries mean anything?
Right.
Does citizenship mean anything?
Right.
And in this case, that just as I think there have been a lot of claims that foreign law should penetrate into the United States, this in defiance of past traditions and past law. We now have a case where American law is going to interpenetrate the whole world, including the sphere of combat operations, in a way that sort of raises some very serious questions about legal legitimacy.
Right.
I mean, if it's true that that these rights are not founded on any previous notion of law, where do they come from? How do these 9 people get the right to overturn the decision? In this case, one not just of the president alone, but of the president plus Congress. And I completely agree with you. It would have been a lot better if President Bush had gone to Congress and got this statute in 2002. And I urged that at the time, and I've written about it in 2004 or 5. And there's a line of criticism, and I agree with it, that the Bush administration wasted a lot of time trying to make points about what events in 1973 and the legal powers of the executive, skipping over the pragmatic problem-solving created by the war on terror. They should have got a statute. I agree with that. But now there is a statute. And I understand why the court was tempted to do what they did. But they should have. I think they should have controlled themselves. And I think they gave in to their most imperial instincts for reasons that are understandable, but that are still wrong.
Right. Here, David, though, is where we're disagreeing, and you may accuse me of coming at the same point again, but I think that you're not quite
persuaded by it. Then maybe we repeat it again; it'll sound better.
I think that you're not quite seeing the point that I'm trying to make. So let me try to make it in a slightly different way. And let me quote back to you something you just said. You said, never before has a civilian court tried to second guess the detention of belligerents. Where we've got the issue here is precisely on who makes the threshold determination of belligerence and whether the court thinks that the executive branch has been abusing its discretion to use the term belligerents, to use the term enemy combatants as a kind of blanket basis for detaining people who clearly are not belligerents in some cases. And here's where I think that your psychological explanation and the legal issues begin to merge. That you can't understand this case, as I think, we both agree, without the backdrop of the last 7 years, without the backdrop of all kinds of Bush administration shenanigans, without the backdrop of unprecedented claims of executive power. Here's the difference between this and World War II and World War I and all previous conflicts where we've had POWs, where the civilian courts have been perfectly happy to say, hey, it's none of our business, we don't have a role here to play. We had 400,000 Germans as POWs detained in prison camps in the United States. Those were people, the issue of their status as belligerents in general just didn't arise because they were captured on the battlefield, they were wearing German uniforms, that they were clearly under the recognized command of a nation state. There was a clear declared war going on between nation states. Nobody was confused about whether there was a conflict or whether there was not a conflict. Nobody was confused about whether Private Adolf Schmidt, wearing a German uniform with German insignia, with German identity papers in his pocket, was or was not an enemy combatant subject to the laws of war, legitimately detained by the United States for the duration of the conflict. Nobody was confused about the idea that even though nobody knew precisely when the war was going to end, there would be an end and there would be such things as prisoner exchanges and repatriation. As many people in the Bush administration have said, we're in a radically different situation where we're dealing with people who a loose, shifting cloud of suspected bad guys who, as the Bush administration always emphasized, they don't wear uniforms, we can't figure out who they are. Anybody could be one of the bad guys for 10 minutes and then shift back into not being a bad guy. They're all over the world. We can't distinguish them from anybody who's just a regular old civilian. We're not primarily detaining people so much to incapacitate them as to interrogate them to try to figure out who the hell is and who isn't a bad guy. And that in itself is sufficient to cause some real concern. Particularly when we do have a history of abuses, when we do have a history also of acknowledged openly, there's no reason it wouldn't be, by the military, of a lot of people we pick up do in fact turn out to be the wrong people. That's going to happen in this kind of conflict. That's going to happen. And so when we have that happening, when 6 years go by and we're very, very far from the battlefield, we've got a group of people saying, help, we've been here for 6 years, some of us are still saying we're the wrong guy, this is not a battlefield, that is a radically different situation from World War II. The Supreme Court went out of its way.
It's radically different in another way, though.
The Supreme Court also went one more thing. The Court also went out of its way, in Justice Kennedy's opinion, to make it crystal clear that they're not trying to mess around with battlefield decisions and initial detention that for a reasonable period of time, left undefined, of course, but for a reasonable period of time, no question about it. Of course, on the battlefield, the military has the authority to detain, to interrogate, to treat, as long as they're treating, in proper conditions, subject to the laws of war, detainees. This kind of habeas stiff only sort of becomes an issue when we are talking about years and years going by with no due process mechanism in situations that cast substantial doubt over the question of whether these were ever belligerent in the first place, and raise the question of whether the administration is deliberately abusing the category of belligerent in order to detain people who should not have been detained without any basis.
Okay. Here's though where you've ended up with this line of reasoning. Unlike your Corporal Adolf Schmidt, who, if he was a member of the Wehrmacht, was not ipso facto a war criminal. He was serving a bad regime, but he was in a properly constituted army. On the Western Front, at least, they did largely obey the laws of war. Certainly, they behaved correctly vis-a-vis American, British, and Canadian and other Western power POWs. They acted like a normal army. The members of the Al Qaeda organization are a moral category below those Western Front Wehrmacht soldiers. I mean, they are, just by virtue of who they are war criminals.
That is not true.
That is true. They're illegal combatants. I mean, they're
illegal
things they have to do.
Combatant and war criminal are two completely different categories. There's, first of all,
their legal status are like buccaneers.
Under the laws of war is one made up by the Bush administration. It's not a law of war category.
Rosa, let me just finish my
go on, but
here.
let's come back to that.
Their legal category is like that of buccaneers in the olden days, or spies. And under the very traditional laws of war, that a regular army that detains such people would be completely within its rights to do battlefield executions of them, as that's what happened to Nathan Hale in a much better cause. These are people whose legal status is below that of Corporal Adolf Schmidt, and yet under your analysis they're going to have a lot more rights. That's when Lindsey Graham does those clips that get him made fun of on The Daily Show saying Nazis don't get these rights. What he meant was not Nazis, but the Wehrmacht. I mean, these people are going to have these detainees in Guantanamo and more elevated legal status, more legal rights inside the context of the American legal system than people whose armies did a better job of obeying the laws of war. And that's kind of perverse. And it's true that the Army gets some unspecified grace period from the courts. But it's also true that we've just opened up a door to a completely new era in law that is going to create legal processes as yet unimagined, that I'm sure are going to be, and although we're always assured that they're not going to be cumbersome, they will be cumbersome, of course. And they will open the way to second guessing, and they will also open the way to a lot of there are a lot of conscientious lawyers who, for conscientious and principled reasons, want to do what they think is right and volunteer to serve these detainees, and I think that's often very laudable. But there are a certain number of Lynn Stewarts as well. We remember the lawyer who was sent to prison for passing illegal messages for the blind sheikh in New York detention. There'll be a lot of mischief makers. There'll be a lot of opportunities for mischief in this process. I think that's the thing that got Justice Scalia so upset, is he saw those opportunities for mischief. They're very real.
Justice Scalia is upset because he watches too much 24, but that's a different story.
No, he's upset because he could see. Look, I mean, it is not. I mean, we have a precedent here. We know what Lynn Stewart did in that prison in New York, and it's not hard to imagine how future lawyers, who, by the way, don't have to be Americans, I don't think, can also use this opportunity to make other kinds of mischief.
Well, I think you're conflating. I mean, that's a different issue, and I think that federal courts obviously can make appropriate security-related requirements of the attorneys, in which they will if this issue comes up. But my problem with your argument, David, is it just seems to me to be completely circular. If you start from the assumption that all of these people are, in fact, who the U.S. government asserts that they are.
Not circular. It's an argument about who's the relevant decision maker. That's
and what the Supreme Court is saying, that after 6 years with no evidence, in a kind of pretty dubious claims in the first place, when so much evidence has surfaced that they have been wrong, that at that point you stop trusting the executive branch, and I think they're right to do so. But can I just go back? But
they're overriding Congress here as well as the executive.
Can I just go back? Can I just go back to a point that you made, which I think is a subject that people frequently get muddled up, which is the distinction between combatants who are not eligible, who do not qualify for the protections of the Geneva Conventions on Prisoners of War, versus combatants who have violated the laws of war in a way that makes them war criminals. Those are two different things. You could be a combatant who doesn't follow certain technical rules in the Geneva Conventions, such as wearing a uniform and being part of an organized command structure and so on and so forth, which would therefore, if you are captured, deprive you of the right to say, I am entitled to the POW status and the protections and privileges due to the prisoners of war. That's absolutely correct as a matter of the law of war. That is not the same as being a war criminal. Those are two totally different things. And many of the people who we're talking about, things like even if a combatant is not wearing a uniform, hides behind a rock, not wearing a uniform, lobs a hand grenade at a bunch of U.S. troops, as for instance Omar Khadr, one of the Guantanamo detainees who is going to go before a military commission, was 15 at the time, is alleged to have done, probably did do. Would he, if assuming all the facts alleged by the government are true, would he qualify as a POW? Well, no, he wasn't wearing a uniform, et cetera, et cetera. If he doesn't qualify as a POW, does that make him a war criminal? Well, no. If the facts alleged by the U.S. government are true, it is not a war crime for one combatant to throw a grenade at soldiers on the enemy side. Those are just totally different issues. Which is also not to say, and I completely agree with you, it's also not to say that plenty of Al-Qaeda people are guilty of the most heinous war crimes and crimes against humanity, and they should be punished severely. I think that the total tragedy, going back to our initial point, the total tragedy and the total irony of all this stuff, after almost 7 years since 9/11, is that if the Bush administration, with the people captured right away who were suspected of having committed actual war crimes, e.g. not just lobbying and grenading U.S. troops, but killing civilians, being part of plots to kill civilians and so forth, if they had actually tried to prosecute them in the U.S. federal courts, those guys would probably have been tried, convicted, and shut up in supermax prisons or potentially sentenced to death by now. We wouldn't be having this discussion. Instead, they tried to screw around with this totally ad hoc system, which predictably has been a flop.
Well, the system has not worked. I agree with that. Was it predictably a flop? Well, had it gone to the federal courts, there might have been other kinds of flops too. And one of the problems with the federal court system, and this is where that point about whether when people say that you should regard this as war, not a police action, that's not a statement about how much violence you should use. That's a statement about what rules of evidence you should have. And that I think that the experience of the 1990s in taking terrorists to the court system was not a success in that it meant we were operating blind and we lost the opportunity to lose a lot. A lot of information was lost, and the classic case of, as you well know, the classic case of this is what happened after the assassination of Rabbi Kahana by Sayyid Nasser. There's all kinds of information that was there to be learned that might have prevented the 1993 attack and might have had other beneficial consequences, and it wasn't learned because that's not what law enforcement agencies do. Yeah.
I think that's a different problem, though, again, which has different solutions. I mean, I don't disagree with you that there are all kinds of screw-ups, but I don't think that I think the Bush administration had a throw the baby out with the bathwater response, which ended up making things even worse. I mean, to the extent that there were problems there with communication between different agencies, to the extent that there were relatively minor problems with protecting evidence, what goes out into public, what doesn't, what gets sealed, what doesn't. Those are problems that are all fixable with the federal court system. But in any case,
here what I really am startled by, and what I really when I look at this case, what I really worry about is that in reaction to I think a lot of impulses, some criticisms that are justified, but also a lot of partisan impulses, that people on the liberal side of the spectrum, who may very well be in power after November, are being driven to a position that is so way more generous to enemies of the United States than anything they ever imagined back in the 1990s. And the idea that you would say, well, in fact, that when I'm thinking about Khalid Sheikh Mohammed, that the federal court system is the right place for him, not a drumhead trial, not a military commission. I actually want him in the federal court. That's not where people were in 1998. A lot of you hear from a lot of people on, again, and I'm going to speak very generally, but on your side of the spectrum, who are now saying we reject renditions, even though those were also practices of the 1990s. That they have moved not to a September. It's not true to say they've moved to a September 10th position. I mean, they're rejecting things that were parts of the national defense of the United States in the 1990s. I mean, they are things that they're moving to a position that is. I mean, I don't know where we're going. Back to 1992, 1986, where knowledge is being unlearned. Conclusions are being forgotten at a really remarkable rate. And people are recoiling. People on the left-hand side of the spectrum are recoiling into a position that is absolutely unsustainable. Now, I don't think... Let me say one more thing about this. I don't think that a President Obama will necessarily do all of these things. My guess is that the FBI comes into the Oval Office on the day after he takes office, if that happens, shows him what they're doing and says, which of these things would you like us to stop doing, sir? And we all will hope that that your conclusions don't lead to anything bad happening. And I think being a prudent politician who wants to protect himself from risk, he will allow the FBI to do what it wants to do, and also the CIA and also probably the Army. But maybe not. And maybe what is going to happen here is that you all are talking yourselves into positions that just are so legalistic, so detached from the recent past, that you're going to cripple your own ability, if you're ever in charge, to defend the country.
Well, here's something I agree with you on, David, and then of course something else that I don't agree with, or not that I don't agree with you on, but I think a different way to think about this. I agree that in some segments of the left, the reaction to Bush administration abuses, and there have been abuses, has been to sort of stop believing. It's been a kind of the boy who cries wolf story. That people start hearing enough stories about, oops, we ended up discovering that these various Guantanamo detainees were not combatants at all, so we let them go, et cetera. And they start thinking, well, all these guys must be innocent. All these guys must be actually really nice guys, and we don't believe a word the government tells us anymore. And that's a shame, and that's a shame for all of us. And you're right, because there is a threat. Al-Qaeda is real. It's not a figment of the Bush administration's imagination. 9/11 was not a plot engineered by Bush and Cheney, to win re-election or something. There are bad guys out there who really do want to hurt Americans, and people need to understand that. And I think it's a shame, and it will be a problem going forward. That for which, unfortunately, I think that the Bush administration bears most of the blame. That their own actions have created so much distrust among some segment of the population that's going to be really hard for a new administration, whether it's McCain or Obama, to just get people to start believing it again when the government says, hey, folks, there's a real threat out there, take it seriously, we're not lying to you. Because they've heard so many times, hey, just trust us, from the Bush administration, when later evidence proved that there was all kinds of malfeasance going on. And that is an issue, and I think it's one that an Obama administration would have to grapple with. But here's what I worry about.
Let me say one thing about that. Let me just get you to draw a breath for a moment. Give you a chance to breathe. In Richard, one of the things I recommend to people is that they actually read Richard Clarke's book. I mean, Richard Clarke's book became a prop during various political debates. If you actually read it, the bulk of the book is about the failure of the Clinton administration to defend the United States properly.
Yeah.
And one of the most arresting passages is a scene in which Richard Clarke and a friend emerge from a briefing with some Clinton defense officials. And Clarke says in discuss, what is it going to take to get these people to pay attention to this problem? Is somebody going to have to fly a plane into the Pentagon?
Right.
And, of course, tragically, that's what happened. That there is a long record of failure and inadequacy. It is not because the Bush administration,
sure, there's bipartisan.
They're making that it was because there was a lot of point making. It's true, and I think that's wrong. They're relitigating the end of the Vietnam War. But it's also true that after 9/11, the legal inheritance they had to defend the country was inadequate, and the practices were inadequate. And it wasn't going to take little fixes to make these bureaucracies work better. They work extremely badly.
I agree.
And to a great extent, they continue to work very badly.
Yeah, no, that I agree with you. But here's what another lesson, though, a lesson that we actually learned in Vietnam and then unlearned and learned again in Iraq and in Afghanistan, that I think conservatives reacting to Boumediene, et cetera, are busily trying to pretend doesn't exist, is the lesson of counterinsurgency and counterterrorism work. This is Petraeus's field manual on counterterrorism. And here's the lesson. You worry, and it's fair enough, that the left will get all fixated on legalisms and lose sight of the bigger picture. I worry that the right will get all fixated on, we cannot give any rights to these terrorists because they're evil, why do you want to give rights to them? And they will lose sight of the bigger picture. And the bigger picture, is don't mix up tactics with strategy. Part of the reason why would I like to see KSM in a federal court for the world to see? It's not because I don't believe that military force is inappropriate against terrorism and that we can, rely on, let's just call the judge to fight terrorism. No, of course not. Sometimes you need military force. Sometimes you detain people on the battlefield, et cetera, et cetera. But it's because, first of all, I don't want to give Khalid Sheikh Mohammed the legitimacy that he's seeking. I don't want to let him stand up there, as he's been doing, and say, I am a mighty warrior fighting the great United States. They will try to crush me, but I am a brave warrior standing up against them. I want him to be treated like a mass murderer and a thug, And I want the entire world to see that we are not scared of him, that our 200-year-old federal court system can handle him, that these guys are not going to scare us into surrendering our values and our traditions, that we can handle these guys, that we think that they're thugs, that we're going to deal with them as they deserve, which is as simple criminals. That doesn't mean that we won't fight when we have to, but that when we capture them and they're off the battlefield, that we're going to just treat them like the criminal dirt that they are. And that's what I want to have happen, because I think that in the long run, thinking strategically about how we combat extremism, we don't want to create martyrs, we don't want to create heroes, we don't want to create recruiting posters for Al-Qaeda, we don't want to be tortured, even leaving aside all the moral issues, that our best weapon is our values, it's our traditions, to show that we are not scared of them, that we've got a system that can handle it, doesn't keep us from using military force. And I think that, showing that we can use our courts to prosecute these guys as criminals and lock them up is one of the ways that we do that. And if we get so fixated on, I can't stand it, we're giving rights to this horrible guy, we lose sight of that much bigger picture.
Well, I think the Army is coming to to a realization of the importance of counterinsurgency. And in fact, we have seen over the past year and a half a lot of success from that approach in Iraq. Where, by the way, detainees are considered, or certainly the Iraqi army detainees were considered prisoners of war. I mean, they did have a proper army,
right.
And that distinction was made by the Bush administration.
Right.
One of the questions that you're going to have to ponder in the light of Boumediene is, if an Iraqi is detained by a unit of the Iraqi army with American advisors and is detained in some kind of facility in Iraq where Americans have a presence, does that person have a right of appeal to the U.S. federal court system?
That person has been detained by the Iraqi army in a sovereign state that is not ours.
Well, but it could be maybe an air base where the United States exercises effective sovereignty, or something that's arguably effective sovereignty.
I don't think Boumediene opens the door to that in any way.
Oh,
I think if that person is
the door,
transferred to
the guy may not be able to walk
Guantanamo,
through the door. The guy may not be able to walk through the door, but the door's open.
I think if the U.S. transfers him to a U.S. facility and holds him for 6 years, at that point, yes, Boumediene does suggest he would have habeas rights if they don't do anything with him for 6 years and he's stuck in Guantanamo. But certainly, while he's in Iraq, while he's, in U.S. custody in Iraq for some reasonable period of time, I think the concern about this case is just really overblown.
I will bet you a case of lemonade that we are going to, at some point in the next 10 years, see similar kinds of appeal from Iraqis, or from lawyers, of course, but claiming to represent Iraqis who are detained in something that is arguably, Abu Ghraib, whose prison was that? That's going to come.
Let me put it like this.
And we are going to have now a global pattern of litigation. Now the courts may say no. I mean, they may.
Right.
If I'm right that it's psychological, and if I'm right that Justice Kennedy often reacts to things rather than thinking things through, they may recoil and set limits to their own precedent. They may refuse to allow people to walk through the door they've opened, and they may refuse all of these cases. But the door is open. This litigation, I think, is likely to come.
Here's what I think. One of the things that I don't always agree with Justice Kennedy. He's all over the place in some ways. But one of the points that he makes, which I think is quite right, is that this is fundamentally a pragmatic determination. That there needs to be some accountability mechanism, some due process mechanism. The court doesn't really deeply care that much what it is. That if there had been an adequate one here, they would have accepted. They wouldn't have said habeas was necessary. But, the government had 6 years to come up with one. They didn't do it. At some point, the Supreme Court's going to say, fine, you blew it. Now we're going to use habeas. And I think Kennedy makes it pretty clear that that's the functional concern, is due process and accountability. Would we see something like that coming out of Iraq? Not if there's some functioning process. If the U.S. military, and God, I hope this would never ever happen, if the U.S. military sits on a bunch of guys at a U.S. military base in Iraq for 10 years with no process whatsoever, ever to figure out who they are, guys who they just picked up on a street corner, might the courts get sufficiently pissed off at some point? They say, you got to do something. One way or the other. You got to have some process. That's possible, but that is not such a bad thing.
So
with 10 years.
My case, or 8, or 6, or 4, or 3, 2.
3. Again, you're not going to
getting more and more getting colder.
The point is the courts.
The point is the question's open.
Yeah.
And I agree with you that that's the way they're going to think. But they have opened the door to something that is going to have planetary implications.
If the U.S. government complies with the laws of war, if the U.S. government were to comply with with the Geneva Conventions in the first place, with adequate Article 5 combatant status review hearings in the first place, we're just, this issue is not going to rise. I mean, the moral of the story here, the moral of the story from the beginning, with all this, the whole line of Supreme Court cases, Hamdi, Raisel, Hamdan, Boumediene, the moral of the story is follow the damn rules in the first place, rules which protect our troops as well as other people. Follow the damn rules and you're not going to have a problem.
The moral is guess what the rules are going to be, because they're changing.
They're
and it's a moving target.
Clear.
And
the problem is that
the rules today are different than the rules after Hamdan. These are different rules. The rule in Hamdan was get Congress to pass you a statute. That's the rule. And we now have a new rule.
David, what's happened here is that the Bush administration, for reasons that were frankly stupid, they got panicked. They panicked basically after 9/11. I understand that. Everybody kind of panicked, but they panicked and they started deciding. They had perfectly adequate legal framework to do everything they needed to do to protect U.S. interests, but they panicked and they decided it wasn't going to work for them. They were going to invent a whole bunch of new things from scratch, all designed to shield everything they did from anybody, completely unnecessarily, and they're paying the price for that.
Well, I agree that they were that they departed. I think panic is a pejorative word. I think they certainly took things a lot more seriously than anybody had ever done before. We may have some benefit from that in the relative safety that at least Americans have had since 9/11, since the anthrax attacks, I should say. But was the framework adequate? 5 minutes ago, I thought we were agreeing that it wasn't. That what was in place before 9/11 did not work. No.
We're not talking about the legal framework. We were talking about interagency communication, whether the U.S. government was doing a good enough job of tracking intelligence, of sharing intelligence, of paying attention, taking it seriously, etc. That's a different issue from whether the law of war framework was adequate for detention and interrogation of detainees.
The institutional and for then the proper punishment of them eventually.
I think was basically
I'm not going to agree
adequate.
with that. A lot of the evidence that would have been available against Khalid Sheikh Mohammed would not have been admissible in a courtroom, that it wouldn't have been. I mean, depending on what it was.
Well, we shouldn't have tortured him, but luckily in his case,
the various kinds of satellite intercepts. I mean, that a lot of the information we know about him is intercepted in ways that aren't necessarily admissible in the U.S. courtroom.
I'll bet.
I think that's the thing they're worried about.
I'll make you a bet. Should it ever come to pass that Khalid Sheikh Mohammed is prosecuted in federal court, I would bet you 2 cases of lemonade that he will be convicted without much difficulty.
Well, he may well be, but a lot of the evidence that would be used against him in a military tribunal would not be admitted. And that is knowing and where the administration was in advance, where they were in October and November of 2001, was they were anticipating they were going to have a lot of information about these detainees that you couldn't use in the courtroom.
Yeah.
And
again,
that was when you say the institutions were adequate, that was the problem. The problem is with the rules of evidence allow you to admit these intercepts and various things.
I would encourage you. There's a terrific report that Human Rights First recently put out, looking at the last 15 years of terrorism-related prosecutions in the federal courts, which I encourage you to take a look at, which does a pretty good job of debunking that argument that the evidence wouldn't have been able to come out. I think that's just an overblown concern.
Well, I don't even know how you'd go about. I'll look at the report.
I'll do
it strikes me as kind of an implausible claim, because you can study the cases that happened. You can't study the cases that didn't happen.
Sure, but again, I what can I say? I think the record is pretty clear on this. That no, the federal courts aren't perfect. No system is perfect. But frankly, their track record is pretty good at prosecuting and putting away terrorists, whereas the record of the military commissions the Bush administration came up with has been horrible. We've got nothing. It's been,
true.
And this is called letting the perfect be the enemy of the pretty damn good. And meanwhile, as the economists say, we've got all sorts of externalities here. This goes back to the sort of counterterrorism, counterinsurgency point. While they've been screwing around with the military commission system and so forth over almost 7 years, while they've been screwing around with it. We've been just handing Al Qaeda a bunch of recruiting propaganda. This was not a smart plan.
Well, I don't know that Al Qaeda's recruiting propaganda is drawn from the annals of human rights first, but I think
it's drawn from the Bush administration. Worse, it's drawn from the Bush administration. That's the problem.
They have their own distinctive arguments. Anyway, we are at the end of our time.
We are indeed.
It's a fascinating thing to talk to you. I'm delighted to have had this exchange. I hope I have a chance to
one or the other of us, or both of us, will be drinking a lot of lemonade at some point.
Nice to talk to you. Bye-bye.
Okay, nice to talk to you, David. Bye-bye.